good afternoon, everyone. My name is John Hurley. I'm your judge this afternoon. We're in First Appearance Court. Today is the day the court determines whether or not there's probable cause for your arrest. We're not here for a trial, so you don't need to tell us about your case. Save that for your attorney in a private meeting. You have the right to remain silent, but if you give up that right today, whatever you say can and will be used against you. Also, if you have a private attorney, when you called up, let me know who that is. We'll contact your attorney and let them know that you're in court. May I see Carrie Hewitt? Carrie Hewitt, please.
Your Honor, we had a little delay with her. She's en route.
Okay, can you give it 5 minutes or so?
Yeah.
Yes, that'll be good.
Okay, I think we have
Mr. Hinchberger, Judge,
Hinchberger.
is the first one, if we can address him. David Hinchberger. Judge, he's in the back row. I can have him sit down.
That's Hinchberger?
Yes,
Oh.
that's David.
Have a
He's here.
seat, Mr. Hinchberger.
Mr. Durkee is here on behalf of their surety.
Okay,
So if I can address just briefly and tell the court, we have provided Ms. St. Laurent with the documentation showing that Mr. Hinchberger's father-in-law, Stuart Manning, has been the source of the $15,000 bail bond premium
okay,
paid to a signature bail bonds. We've also provided Ms. St. Laurent with the last 4 months' bank statements from Mr. Manning and a year ago's bank statement, showing that at the time a year ago and leading up to this past week, Mr. Manning had in excess of $30,000 in his bank account, which was the source of the $15,000 bail bond premium. Provided him with an affidavit, Ms. St. Laurent with an affidavit from Mr. Manning as well as she has seen his driver's license. He is not here physically in court. He's at Mr. Durkee's bail bonds office because he is suffering from COPD and lung cancer. And just to walk over here, he's had bone cancer surgery. It's a little stressful for him, but should the court want to speak to him, I believe that at least the premium issue is now satisfied with Ms. St. Laurent.
what about the issue of the collateral?
Let me tell you about the collateral. Mr. Hinchberger's brother-in-law lives in St. Clair, Ontario. He has property that is on the St. Clair River that he purchased in 2010 and paid $178,000 for it.
That's in Canada.
Yes,
Okay.
Mr. Durkee has spoken with legal counsel up in Canada and the family, and they are going to be executing collateral bail bond mortgages to Mr. Durkee on that property. He is comfortable that the property is valued well in excess of the $150,000 bond.
In Canadian money or in US money?
Either way you value it, it will be worth more than $150,000.
I'm just curious because I've never had this come up before. Let's just say the worst case scenario happens. We had to use that collateral. That
He
collateral
would
had
have
to
to.
come to play. What do you have to do?
We
You
were
have to
talking,
go up to
we were
Canada
talking,
and hire a,
we were talking in US dollars,
right?
and in excess of $200,000 was my conservative estimate.
No, but I'm talking about, I'll assume that's accurate, but what do you do about, I mean, do we have to go into the court of the exchequer or, I'm joking.
He'll file a mortgage for it.
What's the
Well,
court?
here's what we do, I hire an attorney in the local area that this property is, and then the gentleman that's pledging this property is a CPA that works for a real estate office, so he already has somebody in mind. And then once it's approved, then I will go ahead and execute this mortgage using the local attorney, who will then record the mortgage and send it down to me.
That's how they do it in Canada?
Absolutely. This
Same
is not
as in
the first
America.
time I've taken a piece of property in Canada. I've been 33 years of doing this. I've done it
I've already
twice.
thought about it.
It's not the most idealistic, but this is what we have,
Okay,
and we're good.
all right, well, I'm always,
And
Yeah.
frankly, Judge, Mr. Durkee's going to be responsible to the court for the $150,000, whether he doesn't have sufficient collateral. I understand they give you some concern if you have a thought as to the defendant therefore would flee. But Mr. Hinchberger has no prior arrests. There's no criminal history. The bondsman is the tie. They've hired me to represent him in the case.
Sure.
And frankly, in the almost 32 years that I've been a member of the bar and practicing criminal defense primarily here in Broward County,
right,
I can count on less than 2 hands defendants that I personally have had failed to appear in court.
right, okay, so.
May I respond, Judge? Ellen St. Laurent for the state.
Imagine. Go ahead.
No, actually, Judge, there's certain things we agree upon.
Okay.
I've had an opportunity to vet the premium source from Mr. Stuart Manning. He's got a legitimate source of income, and it appears that he's got sufficient funds to post to pay the premium. where we are.
What I know you're gonna argue about, and then I'll show you that I'm right, but go ahead.
Okay.
Go ahead, I know it.
All right, listen, as it stands right now, I mean, I have a problem with the process that we had, because with all due respect to the court,
Right.
if you agreed with the state that the collateral portion of the bond conditions had not been met and took this individual back into custody, Mr. Durkee knows this. As soon as he posts the bond, as soon as he gets out that jail door, that bondsman has earned that premium. And if he goes back in, although Mr. Durkee might do the right thing and either return the premium, or if they ultimately were able to post the bond, do it as a, agree to a reinstatement of that bond so that he wouldn't have to post again. The process itself is fraught with problems, because I know a lot of bondsmen that won't do that. Hey, I earned my money and that's it, too bad.
But that-
So,
in
having
fairness,
said
isn't
that, we're
true?
here.
You could make that argument in every case, right?
Well, if the bond conditions are in,
Bondsman, you could say, well, maybe the bondsman is not gonna do their duty.
no, what I'm saying, Judge, the reason I wanted to bring the process to the attention, then I'll get to the issues specifically as it relates to this defendant, is that the process of allowing the defendant out and then saying, come back and show me you've got a legitimate source of a premium, and that you've got enough collateral to cover the penal amount of the bond, is problematic in that, what if they can't? Number one, it
She
just...
wasn't here for the hearing.
And I'm not, listen, I know Ms. McKenzie agreed to it. I just want to know, this court, because you obviously handle bond issues on a daily basis, why that is one of many reasons I see that as a problem. Having said that, we're here now. So if I could finish, Keith,
Okay.
I didn't interrupt you.
Of course.
We're here now. And they have, I agree with them that the premium comes from a legitimate source. As to the collateral, though, and I met with Mr. Durkee about an hour ago, at length in my office, and I said, show me what you have. Forget about the fact that they could be a little bit short in collateral when it comes to the Canadian, because what they have proffered to me is what the individual paid for the property 5 years ago, and documentation as to what they believe and it's printed from the municipal property assessment from, I assume, the area in Ontario that this property is located, yes.
Does this defendant have an ankle monitor on?
No.
Okay, keep
Okay,
going.
so my first issue is, we may be a little bit short on the collateral, but that's not the big issue. At this point in time, there's been absolutely nothing presented to the state or to the court in terms of a title search or anything that would show whether or not there are encumbrances on this property. The only thing that Mr. Durkee could provide to me is that the defendant's, is it brother-in-law, am I correct? I don't want to mix them up. Is this his brother-in-law? That this defendant's brother-in-law, it says it's unencumbered. I'm sorry, that is not something the state's comfortable with, that I can say or that the court, if the court thinks that collateral is appropriate so that, as Mr. Seltzer said, somebody has skin in the game, besides the bondsman who obviously wants to look for them because they have a financial incentive to do it, but that a family member, that the defendant knows that a family member is going to lose a piece of property. That is big incentive for a defendant to show up. And as we speak right now, other than the property owner's word for it, we have zero documentation. I did tell Mr. Durkee that once they're able to, if they can, satisfy the state and the court as to the value of the property, minus any encumbrances, if any, I have no problem with the fact that they need some time to tie up this property. To get the contingent mortgage in place, to record it in Canada in the appropriate province. And I asked him how much time he needed. He said 3 weeks. I said, I'll give you 30. That's not the issue. The issue with me, Judge, is as we speak, again, they might be a little short on the what the property is worth, but in terms of whether or not it's encumbered, we have absolutely no.
The issues are, you don't know whether it's encumbered, and you don't know when it can be encumbered by this case, right?
I don't know. I don't have an issue. Let's say they were able to have given me a title search today, and I was comfortable that the collateral was there. I would have no problem giving the defense 30 days to tie up the property and then show proof of a recording of a mortgage in the appropriate province in Canada. So that's not my issue right now. My issue right now is that there's been zero proof provided to the state or the court as to whether or not there were any encumbrances on this property.
Let me ask you this, what if you just gave him 30 days to figure out whether there's encumbrances? figure out everything in one big ball of wax. I mean, if we're letting the defendant out, and we have an attorney, we have a bondsman who both have good reputations, you know, he's lawyered up, he's got a bondsman that's been around forever.
Electronic monitor, Judge.
No,
Well, I didn't ask if you were agreeing, but the question was being directed to me if I can finish.
I didn't do what I was supposed to do.
If the issue is whether it's encumbered or not, I mean, it seems like that would be all a part of one big effort to get this thing done.
Well, Judge, with all due respect with the court, I have to respectfully disagree. Because if this court found, the original judge that signed the warrant found that it was appropriate to require the defendant to put up collateral to, you know, for the penal amount of the bond, and this court found that also to be appropriate, if that's the case, we don't have it. And if you're saying, let's give them time to do it, then until they can do it, if you want to give them 30 days, Judge, I'm saying, put them on a monitor.
There was no such finding made, Judge. Judge, the parties agreed, I wasn't here, that he was not a risk of flight requiring a monitor. There's nothing that has changed in the 48 hours that would now require a monitor.
Well,
There is no motion to modify his conditions of bond either. You don't have authority to do that today.
Well, Judge,
Okay?
may I
Judge,
respond?
Judge, they asked for a Nebbia hearing. I don't know whoever has read the Nebbia case. The Nebbia case doesn't point to any of these things that Ms. St. Laurent is saying. This is a case from 1966 out of New York in the federal district court. The Nebbia doesn't say that the court has to be assured whether there's an encumbrance on the property, whether it's free and clear. What it says is...
Let me just say, I think that was there a separate order?
Yes, sir.
Which said Nebbia plus?
Yes,
Boom, boom, boom.
that the bond had to be collateralized.
Nebbia
Where,
case.
where does that say?
I'm familiar with Nebbia, and I'm sure this court is too. That's a separate issue. But let's go to the original order, Judge. The original,
Judge, it's in their arrest affidavit.
it's in the
Signed by
arrest
Judge
affidavit that was signed, but what judge signed
Judge
signed the warrant?
Robinson, and also Judge Hurley, we modified it down by $600,000.
I thought there was an original order, separate order, that said Nebbia plus this, plus
Yes.
that, and went down the hook.
And that's
that order?
what Mr.
Judge
Seltzer,
Robinson or you?
No, I didn't write it. It's kind of a form order that I see attached to a lot of
It's
these
in
cases.
the arrest affidavit. It's in the last couple of pages of the
Judge.
arrest
I
affidavit.
mean, I don't know if Mr. Seltzer thinks it's necessary to school us on what Nebbia is, but it's not.
We don't need to relitigate the
Why
whole
don't
thing
we-
right now. Hold it. What do you suggest?
Leave it exactly as it is. If you have some concerns yourself about the collateral, in conjunction with what Ms. St. Laurent did, reset the matter in 30 days before you. Let him remain out as he is. He showed up here today.
And my response, Judge, to say, I mean, I can tell you I'm looking at his David, and it appears he's not a citizen of this country, so he obviously has ties to Canada because his brother-in-law is putting up a piece of property.
He surrendered his passport. That was the main thing.
Well, does he have a Canadian passport?
Let's be realistic. The passport, you can
He has
cross.
a
Right.
wife and 2 minor children.
I understand.
He has a home in Port St. Lucie. His father-in-law will put up his mobile home, if that's a concern, that's here in Port St. Lucie for collateral.
Yeah.
But Judge, let me, the gentleman that's putting up this property, and I've spent the last 2 days speaking with him, he's a CPA there. And he works at a real estate firm. So when I was speaking to him about he sent me the paperwork, which she isn't aware of, that he paid $178,000 in cash for this
How long
property
is it
5
gonna
years
take
ago.
you to put this all together?
I asked for 3 weeks, she said she'd give me 30 days, so I said, give me 30
You need
days.
you actually need 3 weeks?
Well, Judge, it's gonna take, no, I probably don't. It's already in the works. Once you say it's approved, then we were gonna spend the money to record the mortgage, because it's an expense to the family to do so. It costs several thousand
Could you
dollars.
get it done in a week?
I could probably get it done in 10 days, yes. But it'll be done, and everything that she's asking for a pencil search. I couldn't get that done that
Let's do
quickly.
this. Let's reset this matter for status, not this one table solid. How's that?
Judge, is this case assigned to a judge yet, to a felony judge? Because at some point, it really becomes an issue for the assigned judge and not the magistrate judge, to be frank with the
I
court.
agree with that, but you know what, though? Since I'm familiar with it, you know, all in somebody else's court, when I know what's going on, I think it's just more efficient to do it this way, and I don't relish the fact that this is gonna be an ongoing issue in the courtroom. I do like to have things go on, but since we all know what's going on, I was the one here the day we did the bonds and heard everything. Instead of throwing it on another judge, let's just keep it here for the next 10 days or so, and then after that, we'll let it go. All
Do
right?
we know what judge is assigned to it?
Assigned to Judge Destry.
What?
Destry.
That's true.
I just think that Judge Destry should be on board with that, Judge, before we do it.
No, trust me.
That's fine, Judge.
You'll be fine.
You want us back here 2 weeks from today? Is that what you
So
said?
today's Thursday, how about the following, not next Wednesday, but the Wednesday after? Yeah,
Fine,
how's
the
that?
27th at 1:30?
Okay,
Fine.
how's that? Yeah.
And what are we gonna, they're gonna provide what by the
We're gonna
27th?
get a status that everything's buttoned up, nice and neat, and there's no more
That there's
problems.
Can
an
I-
unencumbered property.
Can we give them a time frame as opposed to I walk in the door and they hand me documentation, expect me to vet it?
It's the day before, could you get all the paperwork over there, Mr. Durkee?
24
I
hours
give you that. I
before.
met with her privately this morning, Your Honor.
Thank you.
And I sent her a copy of the check
All right.
yesterday afternoon.
Pleasure.
Always, Judge, but we have one more.
One more.
We have one more. We're in a little bit of a different posture with
Report the plea trial. I can just walk them over there.
No, could you,
What's, where is it on over there?
could you do this? Could you go over and talk to my J and tell her to put it on the docket for
course.
them?
Of course.
Because
I'll take care of that with Marge right now, Judge.
Okay.
Thank you, sir.
Sorry about
Good-
Can we, just so that I'm comfortable, can we have a notice, because the notice, let's say the unexpected happens, not that I'm saying it's going to, but in order, if, in case this defendant didn't show up, you could not forfeit the bond, Judge, unless the clerk gives the surety notice. So can we have a notice created and given to the clerk from the...
27th?
Yes.
Come on up, sir.
David?
Raise your right hand. Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth?
I do.
Tell us your name.
David Andrew Hinckley?
And you're the defendant on the case of State versus Hinchburg, correct?
Yes,
Your attorney is standing next to you, right?
yes,
Sir, you must be in this courtroom, room 235, January 27th at 1:30 p.m. sharp. Do you understand?
yes, sir.
Thank you. I think that covers it.
No, the issue was the notice to the bondsman, Judge. I'm just asking that the clerk, it can't be from the court.
I received it, it's on, and I understand it, and we will all be here on that day.
Okay.
And I'll
You
let
can't
you
create a
give
court
the
notice?
assistant.
Well, right here,
They don't have that form.
Can we do a short
We don't
order?
They don't have court notices in this courtroom, okay.
we usually don't do it this way. All right, so if you want me to get a court notice to everybody, you want my J to?
Yes, I would like you to do that, Judge.
Get all that in there.
All right.
But the clerk, the notice has to come, by statute, the notice has to come from the clerk, not your JA. So the notice, not an order, a notice has to be done by the clerk. You can do it after the fact,
Hold on.
and make sure it goes out. Can we do?
Patrice.
I beg the court
Patrice
to go,
Wheatley.
Gary Nelson,
Hi there.
CBS 4 News.
Yes, sir.
Please forgive the interruption.
No, I've seen you before, Mr. Nelson.
Well, I've seen you a lot more than you've seen me.
Okay.
Judge, Ms. Sears-Pitowski on page 3 and Mr.
Interrupting the court?
Golden
Yes, sir.
on page 7 are charged with armed robbery with a deadly weapon. They are co-defendants in the
Right.
same case. If I could impose on the court's indulgence to call them consecutively or in tandem.
Well, let me just say this. I already have them consecutively in my docket. I'm going to call them up as soon as we're done with these attorneys, all right?
Your Honor, thank you so very much.
You're welcome.
Judge, can we move on to Christos Rankansis? Is that how you pronounce your client's
Any
name?
questions we can do for you, anything?
Christos what?
This is a related to
Patrice, could you do me a favor?
Rocanis.
Where is he on the docket? Christos, what is it?
Rokanas.
Oh, that's the,
Where's Mr.
that's
Rocanis?
just, okay, sorry, it's not on the docket.
Thank you, Andrew. Sorry. Yeah, put it off here for now.
Okay, now, we're back on the docket here. We're here to state the name of the case again.
Christos, Christos, middle name George, last name Rokanas.
Handy copy on his behalf.
Got him back
Yes,
in the
sir.
back.
He's right here in the plat.
Okay, so, and we have Mr. Coffey, Mr. Durkee. Now, where are we on this?
Much easier.
Thank you.
Much.
Yes. The premium, there's no issues with the premium.
That's correct.
There was a little bit of issue with the collateralization of the property. But
Correct.
I think it's very close, and I think Mr. Durkee made a conservative estimate on the property. It's actually worth a little bit more, and therefore I don't think it'll be a problem.
Okay, Mr. Durkee, how do you feel about that?
That's well said.
All right, now,
We're good.
ma'am, do you have any issues with this?
I do, I have one, Judge. And,
Go
listen,
ahead.
have you had an opportunity to see Mr. Durkee's submission to the state as to the property being used to collateralize the bond?
No, I haven't
Do you have a
seen it.
copy for the court, Mr. Durkee, or should I?
Give Mr.
I
Durkee.
do have your copy that I gave you, the extra copy.
May I approach?
Yes, can I tell you something?
Yes, sir.
I feel like I should get CLE hours
You should.
every time you come into this court, because I learn things about when a clerk has to give the notice. I'm not even joking, but you have educated me about the whole bond thing more than any other thing I've done. I've
Great,
learned
then my
more from
life
you,
is
ma'am.
not in vain, Judge.
Yes. So I'm going to send the form off and ask to have those continuing education hours. All right?
Me too.
And I mean this in a complimentary way. You know it way better than I do.
You have it emailed to you as well, Ms. Ellen.
Okay, so I'm looking, signature only bail bonds, case number. Okay, so defendant and his wife, said property being in St. Lucie, market value $220,000. Property has a first mortgage balance of $123,000. Okay,
And they're saying, if I can,
I was gonna speak to it first, and you can.
well, let me just say, Mr. Durkee and I reviewed it, and based on what he showed me, I agreed with that valuation. We both agreed at an hour ago, or maybe an hour and 15 minutes ago now,
okay.
that he's short on the collateral. He's got about 2/3 of the collateral, not 150,000 that he needed. He's got about 97. Now Mr. Durkee is saying, well, it's worth more than I said in my proffer. I agree with his proffer. They're short. That's the bottom line. So the court, Mark, if you let me finish, it might help you.
Go ahead.
You know, the court, listen, I can't stipulate to a judge. Court might find that that's sufficient, but that's the amount that the state's comfortable in terms of around $100,000 in the property
Okay.
for collateral purposes.
Court's gonna find it satisfied. It's
There you go.
sufficient. Did you use Zillow?
Judge, I use the most concerned effort.
I have an article that I read today. Did you read the Broward Barrister?
I haven't had a chance
About
to.
Zillow?
I've been in court almost all day.
Zillow is, you can't count on it. Sometimes it's,
There's an article where a real estate lawyer talks about exactly this issue and how Zillow, nothing against Zillow, but I've relied on Zillow in here when we've talked about this before, and it says that it's only accurate like 31% of the time.
I would say that's high, because I've seen outrageous things on
We don't
Zillow.
use Zillow for my evaluation.
Nothing against Zillow,
Yeah, gotcha.
but I'm just saying that
May I
there's an
trust you to
article.
get that back, my paperwork for my phone?
And
Okay, see ya. Take care.
what's going on in here?
Judge, she's seen you on TV a lot of times. This is the lady that put up the money.
Mr. Coffey, yes. Only thing that I would ask is, can you give me a time limit under which it would take you to record a mortgage on this property and provide it to the state and the court?
This is a local property. I'm not gonna have that done within, tomorrow's Friday, so I won't do it tomorrow. By Monday or Tuesday, it can be done.
How about 10 days, that they provide the,
Yeah, Monday's a court holiday, Martin Luther King.
I'll give them 10 days. 10 days
I just have
to,
to drive to St. Lucie County and drop it off and record it.
how about 10 days? 10 days to provide the state that they've recorded the mortgage.
Yeah, how about the same date, the same time you're gonna be in here with the other one? Just show us proof at that time.
I'll provide it to her way before. I'll get it to her
Okay,
way
thank you, Judge.
We don't need to be at that hearing though, right?
Nope.
Perfect, excellent.
Thank you.
Now, you're welcome.
A pleasure, Judge.
All right.
See you.
Let me call back.
Well, I didn't mean the procedure. I just meant the technical issue.
Hey, can I tell you?
What the fuck do
Now
you
see
want?
Kerry Hewitt,
I know.
please.
It's like a Saturday Night
No
Live
problem,
skit.
Your Honor.
I know.
Hewitt. Hi, good afternoon, ma'am.
Judge, good afternoon. I appreciate the court resetting Ms. Hewitt from this morning. I represent her on this matter.
She's here on a grand theft from Home Depot allegedly.
Yeah.
So do you have any issue about probable cause?
Well, it doesn't say how much the items were, but other than that, no, I don't have any issues.
I agree that it doesn't say the amount. I'll find probable cause for petty theft.
Whatever.
Defendant is currently being supervised in pretrial services, case number 14-11046,
Judge,
delivery of oxycodone.
I would ask,
Corresponding of probable cause, we actually have pretrial officers.
I would ask that she would be put on pretrial on this case as well. Ms. Hewitt's case is as you notice, is a 14 case. The reason why the case is so old is because there's co-defendants in this case.
Right.
And two, she has been in and out of the hospital since the inception of my representation. She could tell you the sum and substance of her illnesses, but they're very significant. She has no prior record. And like I said, we have a court date on the 25th on her case. I anticipate resolution on the case. And like I said earlier, she's a co-defendant on that case. I don't want to, I think you understand what
I know. Yeah,
she's certainly not going anywhere other than the hospital.
Well, Your Honor, as the court's well aware, when it comes to the issue of revoking, whether it be bond or a pretrial at a first appearance, really that's up to the court to respond.
Yeah, I'm going to release her ROR to pretrial. She's not allowed to go back to Home Depot, any of the Home Depot locations. Do you understand, ma'am?
Yes, I do.
Okay, so
Does,
just, go ahead.
does that mean I'm ROR'd?
Yes, ma'am. I'm going to release your ROR. You're going to get a pretrial release. You have to be there tomorrow morning between 8 and noon, downtown Fort Lauderdale, right across from the courthouse, all right?
And
Thank you, Judge.
And Your
This
Honor,
is-
well, I don't think this is an issue with Mr. Catrone. I do know some judges have taken issue, Your Honor. If you could just make a record that your ruling today doesn't preclude
I'm
this.
not addressing
I understand.
revocation of the bond. If somebody want to bring up a de
Of
novo
course.
review of it.
I understand that,
All right?
100%. I got it. Thank you, Judge. Appreciate it.
Yes, sir. We have a couple of people here.
Thank you.
Which case are you here on, ma'am? Rosenblatt? Come right up here. Now, see, I don't know if it's a Mr. or Mr.
It's
Jonah
Mr.
Rosenblatt.
May jail judge?
Judge, prior to the court, I did speak with the family, and there are some sensitive matters that are going to be discussed regards to diagnosis.
I understand.
Judge, we have no objection to the court going.
So you've been charged with possessing cannabis and paraphernalia, stated no priors.
I'll check to see if there's anything in New York. I don't believe there's anything in Florida. He's not from Florida.
Okay. Stand by one moment. I'll be right back, all right?
System shut down.
Hey, Mr. Miller, will you call me real quick? Thank you.
Excuse me, Judge,
Yes, ma'am.
could we get the
What I'm gonna do? I spoke with the,
Judge, would you appoint our office to represent him?
sure, I'll do that. Mr. Rosenblatt, sir, do you have any money in the bank?
Your Honor, is that the right way to talk to you, speak to you? Can I say Your Honor?
Yeah, you can talk, you can call me Your Honor, you can, yeah, that's fine. Let me ask you.
I just want to be respectful.
No, you're being respectful. Do you have any money in the bank right now?
Well, they took my everything, you know, and they're holding it for me.
No, I understand, but in the bank or any financial institution, do you have any funds available?
Yeah, and I have some cash.
Yeah, but aside from the cash, do you have any money in the bank or in stocks or in any financial
I have
institution?
a few dollars in a checking account.
Okay, so now you've only been down here a couple of weeks from what I understand, 2 or 3 weeks?
Approximately.
You have your mother and your stepfather here.
They're wonderful people.
I understand, I can tell by them being in court, but you live
Just one, Your Honor, if I could just, could you tell them I'm
Far
okay?
Rockaway, correct?
Yes.
Okay, all right. Anything else from the defense?
Judge, as he says, he's visiting from New York. His family, I guess, lives is in Boca. Deerfield. Judge, we're going to be requesting a medical screen, and including a concussion protocol. We're going to be requesting a mental health screen, and we'd ask the court to transfer this case to mental health court.
Sir, today, based on your lack of ties to the community, the facts of the case, which are concerning, and the court does believe you do at least represent some danger to the community by the alleged facts contained within this affidavit. The court is going to set your bond, and like I say, based on your lack of ties to the community, set your bond on count 1 at $2,500, count 2 at $2,500. And your total bond's going to be $5,000 today?
Judge, I'm just going to ask the court, due to the nonviolent nature of the offense, I understand the court's concern about what he may have said, but there's nothing to show that this is continuing and it may be isolated. He does have willing family members to help him get him the treatment we need. I would ask the court to drastically reduce his bond and to transfer this matter over to Judge Lerner Wren.
Understand, the court looks at this case as a case which is unique, exceptional. The defendant allegedly made alarming, concerning comments to people at the Hard Rock, and the court is concerned for the safety of the community based on those statements, based on this court's observation of the defendant today. The defendant appears to have, his in-court behavior appears to be out of the norm. That combined with what the court has witnessed or read in the affidavit gives the court great concern for the safety of the alleged community based on these allegations. That's why the court has set his bond at $5,000, and also the court notes he lacks ties to the community. I'm going to order a mental health screen. The court's going to order this matter be transferred over to mental health court to Judge Lerner Wren, and then he can be.
And Judge, we're also requesting a medical screen with the concussion protocol.
I'll order a medical screen specifically regarding a concussion. And also, sir, I'm going to order you don't return to the Hard Rock, any of the Seminole facilities, the casinos, the Hard Rock. You're not allowed to go back there. All right, sir? Thank you.
What I'll do is I'll email you this guy's info.
Judge, you mind if I ask his parents if they're going to be picking up his belongings from the hotel there?
Apparently, he was staying in a hotel where at the Hard Rock.
Yes.
I imagine you'd want to go stop out there and pick up his clothes.
Yeah, now we have a little situation there. My car was left there, and they said it's not there, the Hard Rock.
I don't know.
That's not your.
I would talk to either security there or the
We'll
Seminole
go
Police
over there.
Department.
We'll go over
They'll be
there.
able to.
Can he be asked where the car is?
Yeah, okay.
Because they said that he drove the
They said
car out,
he
which
drove it
doesn't
out.
make sense.
You call up the police department and the security. They'll tell you everything you need to know.
Okay.
Your Honor?
Okay?
Will that
So-
be this other?
Judge, apparently the car
Facility?
is not on the casino property.
No, it is on there.
It is on the casino property. Here's the thing. He'll explain it to them when they visit him, and they'll explain to him how he can release all of his property to them and go from there. They can retrieve the car, right?
That would be good. Just one question, Your Honor.
Yes, sir.
In this courtroom, your courtroom,
Yes, sir.
you're the judge.
Yes, sir.
Is that correct?
That is correct.
I know, so, but he was like.
Okay. Do I have the right in your courtroom
Dismissed. Tell him it's going to be
to
it's just not going to be held on those 2 counts on a bond. That's it.
to see my accusers, to face my accusers
Yes,
of what
sir.
I did?
Well, not in this courtroom today,
Just let me-
because
it's
we're
just
not
a
here
bond-
for a
it's just a bond
trial.
issue. I mean,
But it's a
counsel doesn't have
fundamental
to bond.
right that you have to face your accusers
everything else is the
or
same.
accuser in a trial, and that trial is gonna come along in the future, but it's not today, all right?
Judge.
I agree. I hear you. I totally understand everything you said. Thank you so much. I'm a little concerned because I'll just tell you one incident.
No, you don't, let me just say this, sir. You don't need to tell us about any incident. Tell your attorney about those incidents, and then your attorney can tell me on another day, all right?
Judge, I've been led to believe that Judge Lerner Wren
Okay,
might have,
thank you, Your Honor.
might have a docket
Thank you,
tomorrow. If
Judge.
you could contact your judicial assistant and see if maybe she can have if Judge Lerner Wren does have a mental health docket tomorrow, if he can be placed
Let's see Michael Lugo, please.
Judge Miguel, apparently
Excuse me?
he's present at the main. His name is Miguel Lugo, Judge, and he is declining the PD.
Sir, domestic battery by strangulation, tampering with evidence. Didn't we have the
Family this morning.
family this morning
Says the
testify?
officer made the whole thing up.
I know. Court finds probable cause. Does this defendant have any criminal record?
One moment, Your Honor. I don't believe so.
Why is your system not working?
Patrice, do you have anything? I don't know. We're having issues with our system, Patrice. Sorry.
It's not changing down.
Sir, Mr. Lugo, are you currently employed?
Yes, sir.
What type of work do you do?
Work at a condo.
Do you have money in the bank?
Yes, sir.
How much do you think you have?
Probably like 900 to 1,000.
How long have you lived down here in South Florida?
Since 2008.
Do you have family down here?
Yes, sir.
Who do you have?
My mom, my father, aunt.
All right. Did you serve in the military, sir?
No, sir.
Okay. Go ahead. Well, we heard testimony, mitigating testimony, from your I guess, girlfriend, mother of your child. So I'm gonna take your bond today at count 1 at $1,500. Count 2, I'm gonna set that bond at $500. Total bond's $2,000. I'm gonna allow telephone contact only for the time being. You're not allowed to have any you're not allowed to have in-person contact with Tiffany Gold. No contact with Tiffany Gold directly or indirectly. You must stay 500 feet from her at all times. That is where she lives, works, goes to school. Anywhere in between, you're not allowed to possess guns or weapons if you make bonds. So I'll allow telephone contact, all right, sir?
Yes, sir.
Thank you. Okay. Now see Tiffany.
Judge, she's over at the North Broward Jail.
Sears Patowski?
North Broward, Your Honor.
Ma'am, how do you say your last name?
Patowski?
Sears Patowski?
Yes.
Okay, Sears Patowski.
Judge,
Good morning, good afternoon, ma'am. You've been charged with robbery with a weapon. Yes, sir. Go ahead.
I can proffer to the court, I did speak with her that she has no money in the bank, she owns no property, she's from here, from Indiana. I'm going to ask the court to appoint the public defender's office to represent her, and at this juncture, I'm going to invoke her right to remain silent.
Okay, ma'am, can you afford your own attorney today?
No, I cannot.
Okay, would you like me to appoint the public defender to represent you?
Yes, please.
Okay, so I'm going to appoint the public defender. And do you mind if I just ask her about a couple of her
Well,
ties to the community?
well, Your Honor, before we get to that, I'm going to be seeking her to be held no bond.
Okay.
She was here, she was at a halfway house. She's only been here 4 months. She has no property.
Down here for drug treatment?
Yes,
Okay, from Indiana?
correct.
How long has she been down here?
4 months. So,
4 months, okay.
so Judge, she doesn't have anybody to, I mean, even if the court were to set a bond, she doesn't have the assets of bond out.
Let me ask, State,
Yes, Your Honor.
this is a first-degree felony punishable up to life in prison. Are you
Yes,
seeking
Your
to
Honor.
hold the defendant without bond?
Yes, Your Honor.
Okay, State, I've read the affidavit. You want to go ahead and proffer why you believe that this defendant should be held without bond?
Your Honor, both the defendant and her boyfriend, Robert Golden, entered a Denny's located on East Commercial Boulevard in Oakland Park. Mr. Gordon had in his possession a bottle full of gasoline and a lighter, demanding money from the cash register, Your Honor. Victim was placed in fear by these actions and gave the subjects $380 cash. Video surveillance was taken of the incident, Your Honor. Family members of, one moment, Your Honor. The video surveillance was, this story and the video surveillance was placed on the news, Your Honor. Family members of both defendants, I guess, apparently saw the video surveillance and identified both co-defendants, Your Honor. This defendant gave a post-Miranda statement confessing that both her and her boyfriend robbed this Denny's and another Denny's in Hallandale. Your Honor, I would note, even, and I can proffer that the contents of the bottle was not taken from whatever the bottle was used in this incident. But, Your Honor, I would argue, and as the court has found, that they didn't recover this bottle, the bottle that was used. That's all I mean.
Was it a gasoline container or something?
It was, Your Honor, it was a bottle with liquid, and he was holding a lighter in his other hand. Clearly, there's an indication that whatever's in this bottle or is flammable in nature, Your Honor. And as the court has imitated, you have found that it is satisfied by law if a suspect imitates use of a firearm, even if the firearm's not recovered, you take the defendant at their word, Your Honor. And I would say the same principle applies in this case, Your Honor. That clearly the message has been sent to the cashier at Denny's that do what we say, or I'm going to be using this bottle with this liquid and this lighter.
Right.
May I be heard?
Go ahead, Mr. Miller. Do you have an argument today?
I do, Judge. The charge is robbery with a weapon. That is a first-degree felony. It is not punishable by life. The state has to make a factual showing that that there was a dangerous, a firearm or other deadly weapon in order to charge it as a first-degree felony punishable by life. If the state wishes to foreclose bond in this case, there is a procedure. They can file a motion under Florida Rules of Criminal Procedure 2.132, and the court can give the state 72 hours to file the motion and to have it heard before this court. But to try to stretch the facts in this case to make it a first-degree felony punishable by life, I think is inappropriate. They're charged with robbery with a weapon. They are entitled to a bond under that statute. I would ask the court to instead of finding probable cause for a crime that was not charged, that the state file the appropriate motion and bond be foreclosed in that manner.
Well, the state the state could proceed that way, or the state could proceed today the way they're choosing to proceed, which is by finding a proof evident presumption great. But your argument, if I have this right, is you're saying that the defendant did not have a weapon?
Judge, I think I read the probable cause affidavit. There was the probable cause affidavit indicates that there was a bottle and a lighter. There's no proof. There's no factual basis that the bottle contained a flammable liquid. It would have to actually be a deadly weapon, and in this case, there's no allegation that it was actually a deadly weapon. I understand that the person was put in fear. That's fine. I understand the state's desire to hold Mr. Golden and the young lady without a bond, but the proper procedure is not to stretch the charge to cover something that doesn't exist. The proper procedure is to file a motion. They've got 3 days to file the motion, and the court can hear the arguments, and we can make the arguments that day, and you can hold him without a bond. But this is, I think, inappropriate.
Well, the court does not necessarily describe to your premise that there's a proper procedure and improper procedure. There's two different procedures. One is a motion for pretrial detention, and the other one is to ask the court to find proof evident presumption great. It's not one is improper, one's proper. They're just two different procedures. They're proceeding today, I assume, they've told me, under the procedure where there's proof evident presumption great. They're asking that. Now, Mr. Miller has brought up an issue on whether or not that this is not a weapon. Now, the court, let's put it this way. Someone holding gasoline in a bottle or a can with a lighter up next to it, and they're doing it in the course of allegedly committing a crime, and they're attempting to intimidate a witness or a victim to act in a certain way. That on its face seems that would be the use of a weapon. However, Mr. Miller is saying, I'm not trying to put words in his mouth, but I believe I'm correct, that since we don't know what was in the bottle or in the can, we cannot say for certain today that that was a weapon. If it were water or some type of soda water or something like that, it wouldn't really be a weapon. It would be a prop, and therefore it would not be rise to the level of the use of a weapon during a.
And when I've argued, Your Honor has ruled in the past that if someone goes into a bank, hypothetically, and starts reaching under their jacket, says, "Give me the money, I'll shoot you." We don't know if they're holding a gun, but you've said you will take someone at their word. And while, yes, he did not verbally say there's gasoline in this canister, clearly the implication is obvious. Give me the money, or I'm going to use this lighter, I'm going to use what's in this bottle. Your Honor, and if I could briefly respond to Mr. Miller's other argument, I would note, if you look at the arrest sheet, and I spoke with Detective Copley, yes, the statute number that's used is for a robbery with a weapon, but the actual charge he put down was armed robbery with a deadly weapon. I can proffer to the court that was his intent, for it to be armed robbery with a deadly weapon.
Do we know the statute
It's
number?
2A instead of 2B.
So give me the full statute.
812.132A.
812.132A. So you're proceeding under Florida statute 812.132A, robbery with a deadly weapon.
Firearm or deadly weapon, yes, Your Honor.
Today, the court will find there is proof evident presumption great that this defendant allegedly committed a robbery with a deadly weapon, acted at least as a principal, maybe didn't. It appears the allegations that Mr. Golden is the one who held the lighter and the liquid. However, I'm not trying to put words in your mouth, but this would be under the principal theory.
Yes, Your Honor.
She acted in concert, and when somebody acts in concert, there is liable criminally as the person who actually perpetrates the alleged crime. And in this case, this court does note the facts of the case. They're allegedly caught on. We have a cashier named Cynthia Ham, eyewitness. We have a video from Denny's, and allegedly this defendant's family and the co-defendant's family saw the video, and they identified Ms. Zierpatowski and Mr. Golden as the people on the video allegedly committing this crime. Also, the court notes the alleged admission made by this defendant that she took part in this crime, that she allegedly has committed one similar to another Denny's, and that she said she and her boyfriend were both homeless. They have a heroin, crack cocaine, and flakka addiction. Ma'am, the court's going to hold you without bond until further order of the court. Ms. Zierpatowski, the court does find proof evident presumption great today, and that is pursuant to Florida Statute 812.132 alpha. And thank you, ma'am. May I see Robert Golden? Mr. Golden, you two are charged with robbery with a weapon. State, are you again on this proceeding under 812.132 alpha?
Yes, Your Honor, I am.
So that's the statute, robbery with a deadly weapon, the state's proceeding. It doesn't say that on the cover sheet, but it's understood by the facts of the case. Now, state, that would be a first-degree felony punishable up to life in prison.
Yes, it is, Your Honor.
You basically adopting the same argument and the same facts?
Same argument. The only additional fact
On the co-defendant?
with Mr. Golden is that the Denny's employee also identified him with 100% certainty, Your Honor.
Okay. So, Mr. Miller, is there anything you'd like to say on behalf of Mr. Golden?
Judge, we just object to this procedure. I believe this is a miscarriage. I understand why the state wants to hold Mr. Golden without a bond. I just think that this is the wrong way to go about it. So we're going to object for the record.
Well, yes, sir. The court notes your objection. The court is proceeding. However, this court today will find there is proof evident presumption great as to Mr. Robert Golden. The court reiterates Allegedly, he went into a Denny's holding a bottle full of gasoline and a lighter, demanding money. He received $380 in cash, identified 100% from the employee at Denny's. Also, his family identified him through apparently some video that had gotten into the media. And he allegedly made a detailed confession that he and his girlfriend had also robbed this Denny's and another Denny's, and admitted also to having a heroin crack addiction. The court also notes, and I just want to clarify one issue, and the court has said it before, it's based on the Cula case, I think that came out of the 4th DCA.
Well, I don't think it's the Cula case. I think that might have been the name of
Cula was the alleged victim.
Exactly.
In the case, but the court several years ago, in a case of a robbery where a defendant allegedly went into I think a pizza store, and he allegedly said, "I have a gun," and I believe he had his hand in his pocket, pointing it as if he had a gun. And this court held at that time that the court would take the defendant at his word. He ran from the store, he wasn't caught for a block or two, and in that time they couldn't find the gun. Allegedly, he's the one who said he had his finger in his pocket. I take that back. But this court at that time said that the court took the defendant at his word. If this defendant, Mr. Golden and Ms. Sarah Patowski, allegedly go into a Denny's and claim they have a flammable liquid with a lighter, and they're behaving in that manner, the court will take them at their word at this stage that they in fact had a flammable liquid and in that container. So,
Judge, brief response.
yes, sir. Go ahead.
Okay. And the probable cause affidavit that I'm reading does not state that either Miss Tiffany or Mr. Golden stated that the bottle contained gasoline. It is a conclusory statement by the author of the probable cause affidavit. It may have been implied that it was gasoline or some sort of flammable liquid, but there is no statement alleged to have been made by my client. And so I would argue that that case is not applicable to this case. It doesn't fit. And I would again ask that the court grant him a bond in this case if they're not going to proceed with a motion to hold for pretrial detention.
Let me clarify something. You're correct. We don't have in the affidavit the defendant made that statement. However, we do have a confession of the defendant that he participated in this, and the court is drawing the conclusion that it was understood that he was holding a bottle which he purported to be gasoline. Granted, he allegedly, didn't say it. However, the implication seems clear that he was holding a flammable liquid, even though it wasn't stated from what I can see. The implication going up to the cashier holding this with the lighter would be enough that this court is finding that he was in possession of a deadly weapon. Thank you. You'll be held without bond, sir.
Judge, can we get a SAP order for Mr. Golden, please?
Okay. We'll do that.
Thank you. Okay, put in for the program.
May I see Rashawn Walker?
Yeah, I'll let him know. Yeah.
Okay, Mr. Walker, you have a warrant on a reckless display of a weapon. If you'd like to resolve it today, you could do that. Sir, if you want to please, do you want to work it out today? It's a misdemeanor.
1 moment, please, Judge.
Okay.
Judge, just to let you know, because it wasn't obvious, because it's not a drug case. This is out of Judge Zeller's precinct.
And Judge, Mr. Walker wants to go ahead and try and get this case dismissed through the drug court program.
Okay,
So I
I'll
would have
do that. His bond's $2,000 today.
Judge, if you could lower the bond a little bit, that'd be great.
Let me just say, without going too in depth on this, that would cause me great problems
Understood,
if I
Judge.
did
Thank
that,
you.
all right? Thank you.
Off you go. Good luck. Hey, you have a court
Tyler
date
Smith.
Tuesday. If you bond out, go to court Tuesday, 1:30 p.m., okay?
This is the same
Tuesday,
situation.
1:30.
Tyler Smith,
Main jail, Judge. Mr. Smith has private counsel.
who's your attorney, sir?
It's Dan Berman, Judge. Mr. Berman's out of town. I did let him know about the court date and that he's being held no bond.
You'll see the judge on Tuesday, sir. Thank you.
Thanks. Good luck.
Let's see, Juan
Mr.
Perón Cardona.
Spanish, please, Judge.
Well, you know what? He's bonded. So if somebody was Sue over there, could she tell him
No,
he's
she left.
bonded?
Anybody speak Spanish? We'll get the word to him, Judge.
Make sure he knows he only has 10 days to get a temporary driving permit, all right? Thank you.
Thank you, Judge.
How about Jocelyn Smith, Christopher Sorrentino, Philip Sebo?
Hey, it's Eric.
Jocelyn Smith,
I guess
come on up,
Jackie's
sir.
not at her desk. Oh, because it's weird. She sent one of those emails out a while ago,
Hey,
like
sir,
at 1:30.
you've got a cannabis charge,
I
Mr.
haven't seen the
Smith.
I haven't gotten
Resisting
the
arrest, court
hasn't
finds
been
probable
able to
cause.
forward it to me.
Does Smith have any criminal record?
The response that they've
I
taken
think
care
he's
of.
got some small thing in the past.
Judge, Mr. Smith is going to go pro se today.
I understand. Does he have a
I
criminal
mean, I guess I
record?
could.
I'm trying to see
I guess I could check.
system is for,
I guess I could check on this
Mr.
right now. Just
Mr. Smith, you still live on 10th Street and Margate?
10th Street in Margate.
That's my address.
Yes, Judge.
Yes, Your Honor.
Give me a quick moment. Sir, I'm inclined to release you from custody today without paying a bond. However, I just want to find out, we may be able to resolve it today.
Patrice, do you have anything?
Do you have anything on him?
okay, I'll try to find
I'm sorry, Judge. Yeah, I mean, it's.
Please, BCCN.
No, I've got it. It's just our computers are having issues.
Or
I see
don't
it.
you have an ordinance case?
Declined to adjudicate. No prior, Your Honor.
I don't know if you're.
I'm going to release you on your own recognizance, all right? sir? We're going to send you notice in the mail to come back to court, all right?
Yeah, we just have one.
Yes, sir.
You understand? All right, thank you.
No, we have both.
Thank you, Judge.
They have two cases.
Okay.
They have two
So,
different
Judge,
things.
letting you out, you'll get a court date in the mail. Just make sure you come back to court, okay? Off you go. Good luck. Judge, Mr. Sorrentino is present at the main jail. Go ahead.
Oh, it's showing you
Pretty
now.
sure he doesn't have any record.
Thank you.
Resisting arrest,
I
sir,
gotta shut my computer
trespassing,
down.
confined to probable cause. You live in Monroe, New York?
Yes.
How long are you down here for?
Till Saturday.
Okay. Well, what do you do for work up there?
I help my dad out. He owns a lot of rental property and stuff, but I'm looking for a job. I was in the middle of the NYPD process, but looks like I'll have a problem with
I
that now.
wouldn't say that. I mean, if this case
Yeah.
gets taken care of, I mean, you may want to hire an attorney before you leave town.
Sheila.
All right? I'll release you on your own recognizance. However, my suggestion would be you speak with a local attorney, criminal defense attorney, before you leave. And then they can intervene. Maybe they can get the charges dropped. I don't know. But if they get dropped, I'm sure you're open to go get a job as a police officer, all right? They aren't very serious charges, so, all right? I'm going to release you on your own recognizance. Thank you.
Okay, thank you, Judge.
How about Philip Sebo? Philip Sebo?
Judge, Mr. Sebo is present at the main jail. He is from the Czech Republic. He's charged with trespassing. My only issue is whether or not there will be immigration consequences if he were to resolve this case. He's here at language school until August. And so I would ask the court to consider, under the circumstances, to release him on his own recognizance so that he can explore make sure that he's not going to be setting himself up for unintended consequences.
Mr. Sebo, do you understand?
Just a little bit.
Okay, do you have a local address?
Do you have an address where you get mail?
Yeah, I have.
At your school, right?
At my school.
Right.
What's the address at the school?
North Federal Highway. I don't know, Judge. It's not in the PC.
What's the name of your school, sir?
Excuse me?
What's the name of the school?
LAL. LAL.
Patrice, can I show you something real quick? You'll appreciate it.
Mr. Linder, your mic is on.
I'm holding on to this.
Quick moment here. Sir, what's your room number?
281.
I'm going to release him on his own recognizance.
Thank you, Judge. Okay, so he's going to let you go.
Go ahead and,
You're going to go home. You're going to get a letter in the mail.
ROR, can you,
Hi,
put his
Ron?
address here?
Ron?
Will they see what I've done? And
I'm sorry, is this, okay, I'm sorry, yeah, down the wrong number. All right, bye.
Okay, Woodrow Blount, served possession with intent to sell, manufacture, deliver, flacca. I don't have a
Hey,
zip.
is Ron in?
Zip?
Okay, just to give you guys a heads up, this, I'm sorry, I didn't,
I have no idea what it is. Okay. Woodrow Blount, possession with intent to sell, deliver PVP, court finds probable cause. Do we have any criminal record on this gentleman? Sir, your bond was posted. You'll be out of jail shortly. Thank you. Yep. How about Christian Sims, Stefan Iparraguirre, Lazaro Rodriguez?
Mr. Sims is present at the main jail, Judge.
Possession of alprazolam.
His bond may have been posted to 157. We're checking.
Okay.
Iparraguirre.
Bonded.
Sir, no, I'm sorry. Sims, your bond has been posted. Thank you. How about Stefan Iparraguirre?
Judge, Mr. Iparraguirre has an attorney, Josh Rydell. I did send him an email this morning or this afternoon, let him know that Mr. Iparraguirre is in custody.
Do we know, did Mr. Josh Rydell respond? Do we know?
He didn't respond before I came over to the jail. I have his phone number if the court wants.
You want to give it to me?
954
Okay.
779 1711.
Stand by. Mr. Iparraguirre, your attorney is not able to be here. He's got a family matter. So what I'm going to do is set your bond at 1,000 on count 1, 3,500 on count 2. Revoke your bonds on 15-4358 CF10 and 15-1168 CF10A. You'll be held without bond. Thank you. Lazaro Rodriguez.
Judge, Mr. Iparraguirre has wanted to address the court regarding the revocation of his bond.
Go ahead.
I just started school on Monday, and I work at Applebee's as a line cook. Is there any way I could have maybe a GPS monitor or something?
Hold on.
Because I just started school.
Hold on, Mr. Iparraguirre. Wait, you're Iparraguirre. Okay, hold on. Let me look.
The attempt in this case was an attempted burglary.
No, I'm not going to do that, sir. Not under these circumstances. Thank you. How about Lazaro Rodriguez?
Lazaro Rodriguez. Bonded, Judge. Bonded.
Okay, I'm going to get Mr. Shea in a moment, all right, sir? Just for a moment. Let me knock out a couple here. Okay. I need to see Wesley St. Jean, Travis White, Keegan Lawson.
Judge, could we transfer these first two counts to Judge Lerner Wren? I'm familiar with him. He's currently declared incompetent to proceed in.
Count 1, false ID given to the police, no driver's license. Count 1's 100.
He's already in
I'll
court.
send count 1 and 2 to Judge Lerner Wren.
I thought everything goes. If you have a case in front of court, I thought everything goes to mental health.
Count 3, 4, 5, and 6 are all no bond. violations of pretrial. Thank
I
you.
thought
Judge,
if you
can we
were
go
mental
ahead and
health,
transfer
everything should pick up
counts
goes
1
to
and 2
felony
to
mental health.
mental health court, please?
That's what I've done.
All right.
Oh, right. I didn't hear that part. I apologize.
Travis, no problem. Travis White. Hold on.
What the?
That's Char.
Sorry about that.
I'm working on it.
All right, Travis White.
There's another one about to happen.
Judge,
tomorrow.
I spoke with Mr. Wein. I actually exchanged emails with Mr. Weinstein. He asked if it's okay if the court appointed me to represent Mr. White for purposes of this hearing.
Okay. All right, so aggravated assault with a deadly weapon, burglary, armed burglary, possession of a weapon by a convicted felon or resisting arrest, and then state count two is a first degree PBL.
Yes, Judge. Your Honor, I'm seeking to hold Mr. White no bond. I'm relying upon the affidavit, which states that first the homeowner came home and observed Mr. White in his home, in his residence, with one of his bags and his loaded firearm in his possession, at which point the defendant ran out of the residence, where another witness observed him in possession of a loaded firearm, at which point Mr. White pointed the loaded firearm at this second victim, Your Honor. Then law enforcement is called. They set up a perimeter, responded to the location. Sergeant Malucci spotted Mr. White, ordered him to stop. He did not stop. He continued running. A K-9 unit was called to the scene, and they detained Mr. White, at which point they was searched, and a loaded Glock 40 caliber magazine was recovered in his shorts. Your Honor, post Miranda, Mr. White confessed to committing a burglary and stealing a firearm from the residence. He refused to inform law enforcement where the gun currently was.
Mr. Miller, do you have any comment?
Judge, I do not.
Court's going to find proof evident presumption grade based on the facts alleged contained in the probable cause affidavit denoting the defendant allegedly confessed to stealing the gun. There's eyewitnesses to this. And the defendant's going to be held without bond on count 2, safe on count 1, 3, and 4.
Sure. Well, first off, Your Honor, the defendant currently has a case pending before Judge Backman in Rockport for burglary of a dwelling.
And what was the date of arrest on that?
It's... one moment. Well, Your Honor, this just happened January 12th of this year. That case was filed in May of last year.
Case number?
15-36-32 CF10A. And he has had appearances in court, Your Honor, on that case. So
Do you have any criminal record?
he does, Your Honor. 2010, burglary of a structure and theft, 42 months in state prison as a habitual offender. 2009, attempted strong-arm robbery and unlawful use of false name identity, 42 months state prison as a habitual offender. 2002, theft. 2000, he had 7 counts of perjury, violated probation, was sentenced to 16 months state prison.
Okay. All right, Mr. Miller, anything you'd like to say?
No, Judge. We're going to stand muted this time.
Count 1, aggravated assault. Court's going to set that bond at $10,000. Count 2, burglary of dwelling, no bond. Armed burglary. Count 3, possession of a weapon by convicted felon, $10,000. Resisting arrest without violence, that'll be $1,000. Based on your criminal record, the facts of the case, your total bonds, other than the no bond, are $21,000. And the court will revoke your bond on 15-3632 CF10. You'll be held without bond. Thank you. Keegan Lawson. Keegan Lawson. Mr. Lawson, is he over there? We have Keegan Lawson.
Rose Broward, Judge.
Broward, okay, sorry. Mr. Lawson, false ID given to the police, count 100. 2, warrant on a felony, no bond. Count 3, probation violation, no bond. Thank you. Now see, Deborah Ferraro, Kimberly Gleaves. Those are you, Mr.
Judge, all I have left here at the main jail are the municipal ordinance cases. May I be excused?
Sure, thank you.
Thank you. Have a good day. See you tomorrow.
too. Thank you. Deborah Ferrero.
Yeah, their attorney's right there.
Who's Deborah Ferrero?
Take care.
See you guys.
All right.
Okay, I see you, Ms. Ferrero. Ma'am, you have multiple charges of, well, count 1 is a municipal ordinance, count 4 is a municipal ordinance, and count 2 and 3 are no bond holds on felony warrants. Ma'am, let me ask you, are you employed? Do you have money in the bank? Can you afford to hire your own attorney? Would you like me to give you a free attorney today? Okay, so on count 1 and 4, I'm going to appoint Mr. Shade. Okay?
That's your attorney right there, sir.
Mr. Shade, you're appointed.
Okay, Judge.
He's going to call your name.
Ma'am, you're going to be held without bond on count 2 and 3. You see your judge on January 21st and January 25th, and your attorney will be there. All right, ma'am? Thank you.
Bottom right corner? Yeah. That's your attorney.
Now, see,
He's going to call your
Kimberly
name.
Gleaves.
He's going to try to help you. He's gonna appoint you an attorney right now. That's what we got.
Kimberly Gleaves. Where's
Hi,
Miss
Your Honor.
Gleaves?
She's in the unit now. She's in medical reset.
Good night.
If you want me, I could call her up here.
Now, I'll reset this for tomorrow, all right?
Okay.
Friday
Okay, Your Honor.
PM.
Thank you.
Got it.
Okay. Thank you very much.
I think there's only two, so.
Okay.
Yeah.
Let's see, Trent Sims,
I think
Bruce
so.
Dunn, and John Toledo.
Bruce Dunn.
Yes, Your Honor.
Okay, Mr. Sims, violating
Yes,
municipal ordinance. Are you currently employed, sir?
No, sir.
Do you have money in the bank?
No, sir.
All right. Can you afford to hire you an attorney?
No, sir.
Would you like me to give you a free attorney today?
If I need one, yes,
Okay,
sir.
I'm going to appoint Mr. Shate to represent you. Let me ask you, State, can you tell me, Mr. Sims, does he have priors?
Your Honor, let me just, okay, give me BCC out of them. I'll let you know.
147592.
His last arrest in Broward was September 22nd of 2015. And that was for capiases for panhandling, 2 separate cases. Then July 12th, 2015, and that was for capiases on 3 different panhandling cases. February of 2015, capiases on panhandling cases, and they've all been panhandling, obviously.
February of 2015, panhandling. All right, sir, I'm going to go ahead today, and it looks like at least at a minimum last year, you had 6 panhandling arrests last year, and today you're here again for panhandling in Hollywood. And let me see, you're approaching vehicles, soliciting money from the occupants. Ongoing problem with Sims soliciting at the location. So I'm going to set your bond at $250, Mr. Sims, and remind you that you're not allowed to panhandle down in Hollywood, all right? Thank you.
Yes, sir. All right.
Here you go. Yeah. Hey, what about Bruce Dunn? Hey, Mr. Dunn, how you doing?
Not too good, sir.
Okay,
I'm here.
I'm going to appoint Mr. Shate to represent you today, all right? And when it comes to panhandling, I know you've been through here more times than we can probably calculate right now, but what was like, do we know when Mr.
Last
Dunn-
time, I just
Has it
need
been
his,
within the last 3 weeks, Mr.
just
Shate?
need his number.
I don't, not for me, Judge. I haven't seen him in the last 3
Yeah,
weeks.
I don't,
Maybe,
it might be a little longer, but I just give his
Mostly
number.
open container.
765313. Wait, no. Sorry, I got the wrong one. How about 764605?
It's been about 3 months, Judge. October 14th of last
What was he
year.
in for then?
That was, yeah, let me see when he got out. Yeah, he got out October 30th, and that was for a capias on an open container and a soliciting panhandling.
Panhandling? Okay. I'm going to go ahead, Mr. I know you don't have any money, but we've been many, many times for panhandling in the court last year. October, same thing. And what I'll do is I'm going to set your bond at $250. I'm going to appoint Mr. Shate to represent you, all right? Thank you, Mr. Dunn. All right, John Toledo. Hey, Mr. Toledo, you have 3 different cases here. There are warrants for sleeping on city property, 2 open container cases. Mr. Toledo, are you currently employed?
Not at the moment.
Do you have any money in the bank?
No.
Who's going to help Bond get out of jail today? Anyone?
Not at this moment, no.
Would you like me to give you a free attorney here in the court? He can help you today.
I'm sorry.
Would you like me to give you a free attorney to help you today?
Yes.
Okay.
Yes,
So I'm going to
please.
give you Mr. Shade on each case. Mr. Shade, I would just as soon if he wants to work this out and plead no contest, let him get out of jail today.
That's fine, Judge.
Sir, if you want to plead no contest, cases are over with. No trial. You're not going to have your day in court. They're wrapped
No.
up right now. Would you like to do
No
that?
contest.
Okay.
Yes, no contest.
I'll withhold adjudication. Good luck, sir, all right?
Thank you.
Yes, sir. Okay, Mr. Shea.
That's it? Okay.
How about Orlando Martinez?
Okay, thank you.
Okay.
Yes, sir.
Mr. Martinez, you're here for panhandling. Are you currently employed? Mr. Martinez, are you employed?
If I employ
Do you have a job?
No, no,
Do you have
no,
money in
not
the
right
bank?
now. No.
Would you like me to give you a free attorney today?
If I have to, if I need it, yeah.
Okay, I'm gonna give you Mr. Shea. Now, State, can you tell me about Mr. Martinez's record?
I just need his BCCN.
766-218.
766-218.
Correct.
10/27/15.
Hold on one second. Hold on. Okay. Orlando Martinez.
Yes,
When
sir.
was the last time Martinez came through state?
It was, I think, October 27th.
And what was that for?
Theft and heroin.
Came through on heroin?
Yes.
And what, anything else?
Before that was like 2012.
Mr. Martinez, would you like to plead guilty or no contest today?
Yes. No contact.
Do you understand your case is over with? There's no trial? You're going to leave jail today?
Yes, sir.
How do you feel about that, Mr. Shea?
That's fine, Judge.
I'll accept that or withhold adjudication. Thank you, sir.
Thank you. So, I just jail today, sir.
Oh, I didn't hear that. He said that also was all the way by the elevator.
I got
That door open. We just pulled out.
Uh-oh.
For some reason, I'm trying to get through.
Yeah.
Can I talk to you real quick? Up here.
Hey.
No.
Oh, okay.
No, you're not.
See, Stan, what do you tell me about Sarah Wright, Alex Johnson, and Vincent Skanes, or even RRs?
Oh. Okay, Skanes, Sarah Wright, we don't have to do anything.